Is it actually possible to lose your U.S. citizenship? The short answer is yes. And in certain situations, it can happen faster and more quietly than most people realize. Many Americans assume that once citizenship is granted, it's permanent, untouchable, and guaranteed for life. You get the passport, the right to vote, and full legal protections. End of story. But that assumption isn't entirely accurate. Welcome to US Policy Brief, your trusted source for the latest updates on US immigration, visas, green cards, and citizenship. I'm your host, Daniel Brooks. US citizenship is one of the strongest legal statuses in the world, but it is not bulletproof. Federal law outlines specific pathways through which citizenship can be lost, and these processes are actively enforced by the government. These aren't hypothetical loopholes, they are real procedures, backed by court decisions and handled by federal agencies today. In this video, we'll break down how US citizenship can be lost, both voluntarily and involuntarily. We'll explain the legal framework, clarify common misconceptions, and walk through the scenarios every citizen should understand, especially naturalized citizens who often assume their status can never be questioned. Before assuming your US passport guarantees lifelong protection, it's crucial to understand how the system actually works. When it comes to citizenship, what you don't know can matter more than you think. To understand how citizenship can be lost, we first need to define who counts as a US citizen. There are two main categories. The first is citizens by birth, individuals born on US soil, including US territories, or born abroad to at least one American parent. The second group is naturalized citizens, people who were not born American, but earned citizenship through the immigration and naturalization process. On paper, both groups enjoy the same constitutional rights. They can vote, hold a US passport, work freely, and receive federal protections. But legally, there is a critical difference when it comes to revoking citizenship. The government treats these two categories very differently. Citizenship by birth is almost always protected under the Constitution. Citizenship through naturalization, however, is the result of a legal process, and that process can be reviewed, challenged, and, in rare cases, reversed. The most straightforward way to lose US citizenship is voluntary renunciation. This is not something that happens accidentally or casually. Posting online, sending a letter, or making statements on social media will not suffice. The process is formal and deliberate. To renounce citizenship, you must appear in person at a US embassy or consulate outside the United States and sign an official oath confirming that you fully understand the consequences. There is also a significant financial cost, over $2,000 in government fees in recent years. Once complete, renunciation is permanent. You lose your passport, voting rights, and access to federal benefits. Returning to the US later requires applying for a visa like any other foreign national. There is no automatic path back. Thousands of Americans choose this route every year, often for tax reasons, since the United States taxes based on citizenship rather than residency, or for personal, political, or lifestyle reasons after committing to life abroad. The key point: once citizenship is voluntarily renounced, there's no undo button. Now comes the part that surprises most people: losing US citizenship without ever choosing to give it up. The government can revoke citizenship through a process called denaturalization. While less common than voluntary renunciation, it is very real and continues to be enforced today. Denaturalization occurs when the government determines someone should never have been granted US citizenship. The most common reason is fraud or misrepresentation during the naturalization process. Examples include hiding a criminal history, using a false identity, failing to disclose past military service, concealing political affiliations, or withholding involvement in human rights abuses. Even seemingly minor omissions at the time can become critical later. Importantly, there is no statute of limitations. It doesn't matter whether someone became a citizen 5 years ago or 25 years ago. If the government uncovers evidence that the original application was materially dishonest or incomplete, it can move to revoke citizenship through federal court. This is not just theory. In one case, a man from Bosnia, who had lived quietly in the US for years, lost his citizenship after investigators discovered he had participated in war crimes during the Yugoslav Civil War, which he had intentionally failed to disclose. In another case, a former Nazi concentration camp guard who had lived in the US for decades was stripped of citizenship and deported after his past was uncovered. Fraud is not the only factor. Associations also matter. If, within a certain period after naturalization, a person joins an organization that advocates the violent overthrow of the US government, serves in a hostile foreign military, or assumes a significant role in a foreign government without authorization, the government can re-examine their citizenship. Even without direct violence, such actions can raise serious legal questions about whether citizenship was obtained under false pretenses. Many people misunderstand dual citizenship. In most cases, holding 2 passports is legal, and millions of Americans do it without issue. Simply having citizenship in another country does not automatically endanger your US citizenship. What matters is intent. If someone obtains foreign citizenship specifically to renounce US nationality, swears exclusive allegiance to another country, or engages in activities that directly undermine US sovereignty, this intent can have legal consequences. High-level positions in a foreign government, taking oaths rejecting US loyalty, or politically acting on behalf of another nation may trigger scrutiny. These situations don't automatically result in loss of citizenship, but can prompt legal review if US allegiance is considered formally abandoned. In rare and extreme scenarios, treason or armed rebellion can result in citizenship revocation. Convictions for treason, acting as an agent for an enemy government, or participating in violent rebellion against the US may lead to citizenship loss alongside criminal penalties. These cases involve full federal court proceedings, including appeals, and the legal burden of proof is extremely high. The Department of Justice maintains a dedicated denaturalization unit. Working with Homeland Security, investigators review immigration records, biometrics, and historical data, sometimes decades old. If fraud is proven in federal court, citizenship is revoked. Passports are cancelled, voting rights lost, and the individual becomes deportable. For those born in the United States, citizenship is nearly always constitutionally protected. Rare exceptions exist, such as falsified birth records, but these cases are extremely uncommon and difficult to prove. US citizenship is powerful, but not unconditional. It can only be lost through voluntary renunciation or proven fraud. The government cannot revoke it casually or without due process. When the legal standard is met, however, the outcome is permanent. If this explanation helped you understand these laws and how to stay informed, subscribe to US Policy Brief. Knowing how citizenship works isn't about fear. It's about understanding your rights, responsibilities, and the system that governs one of the most valuable legal statuses in the world.